Good afternoon and welcome everyone. My name is Ellie Garrity, the Manager of Alumni Career Programs with the Alumni Association. We are so excited that you are able to join us for today's webinar, Patent Primer, Understanding the Basics of Patents and Patent Law, presented by Tom Bassolino. This webinar is part of the Alumni Association's Professional Development webinar series, in which we hope to provide thought-provoking and valuable content that will help alumni alike and alumni like you achieve your personal and professional goals. If you know any fellow Terps that may have a great topic to present on, or you yourself would like to present on one of our webinars, please let me know. Okay, we have a lot of information to cover today, but we will be taking questions at the end of the webinar. Feel free to submit any questions using the question box located in the GoToWebinar control panel. Now, about our presenter, Tom Bassolino, graduated in 2004 with his mechanical engineering degree, is a patent attorney specializing in patent preparation and prosecution for inventions in the mechanical, electrical, and software-related arts. Tom founded his patent law firm, Bass Patent Law, LLC, in 2018, and his practice includes drafting, filing, and prosecuting U.S. PCT, national stage, and international patent applications. Tom has worked with individual inventors and Fortune 500 companies alike located throughout the U.S. and worldwide. Tom is registered to practice before the United States Patent and Trademark Office and is admitted to the practice of law in Maryland, New York, and the District of Columbia. Tom is also a proud Terp and Maryland Alumni Association lifetime member, as well as a member of numerous legal and engineering trade organizations. And now we will get started. Tom, feel free to take it away.
Thanks so much, Ellie, and thank you to the University of Maryland and the University of Maryland Alumni Association for hosting this webinar, which hopefully you will find to be helpful. I felt that there was a need for a foundation of knowledge in the patent space for business people in general, and in particular, people in startups and entrepreneurs. I attend a lot of conferences and expos where sometimes I get questions or I hear things that make me get a little bit of chills in the patent space because patent law in general is sort of unforgiving. And if you lack this foundation, this basic foundation of knowledge of patents, you can make some pretty big errors in going along. So hopefully this presentation will go forth to try to fill that knowledge gap. So before I go on, I'll just give my lawyerly disclaimer by saying that this presentation is for information purposes only, and it shouldn't be interpreted as legal advice. Hopefully you will learn something. So what is a patent and why should you care? So a patent is an intellectual property right granted by the government for inventions. So for this bullet point, there's a few things that I'd like to peel back just in this one short bullet point. One is the word inventions. So when you think patents, you should think inventions. This is the easiest rule of thumb way to distinguish in the area of intellectual property law, patents from the other areas, such as trademarks and copyrights. And later on in this presentation, actually in the next slide, I will try to distinguish these other forms of intellectual property so that you won't conflate them in your mind. So patents, inventions, that's an easy rule of thumb. The next thing I'd like to kind of peel back on this bullet point is the term intellectual property. So the acronym or abbreviation for intellectual property is IP. So if you hear me referring to IP, I am talking about intellectual property, which is just the area of law that covers things like patents, trademarks, copyrights, and trade secrets, which again, I will distinguish for you so you don't confuse them with patents that are dealing with inventions. And the other thing I'd like to talk about the term intellectual property is that I think it's called intellectual property for a reason with the emphasis on the word property. It is sort of analogous to real property in that it's fully transferable. You can buy a patent, you can sell a patent, you can license a patent, which can be exclusive or non-exclusive. There's all kinds of ways that you can exchange patents. And so they're fully transferable and they're very flexible. So what does a patent actually give the patent owner? Well, a patent owner that owns a patent may exclude others from making, using, and selling an invention for a finite period of time. So that is a extremely powerful legal tool for companies, innovators, and inventors. The ability to exclude others from making, using, selling, or importing your patented invention for this limited amount of time is very powerful. Think about if you have a company that revolves around a widget, you manufacture and sell this widget, and you have a patent that covers this widget in a pretty good way. That means that essentially for the time of that patent being in existence, you can have the opportunity to exclude others from making, using, and selling that widget, essentially creating a finite monopoly for you and your company, which obviously is a hugely beneficial and valuable tool for you and your company. So why would the government, who grants this right, give this to patent owners? Why would patents be so important that they would give this limited monopoly to people coming up with these innovations? Well, the answer sort of deals with, it usually revolves around the aspect of public disclosure. And there's a few things there that I'd like to talk about. So one is, one of the requirements to get a patent is when you file a patent application, you need to fully disclose your invention. That means that you need to be able to enable someone else from reading your patent application to be able to make and use that invention. You need to describe it so well and so detailed that someone having a similar skill in that technical art field would be able to read your patent application, understand it, and make and use the invention. And so when you file a patent application, if it actually grants, it will be published. And so the world will be able to see your innovation. And most patent applications will publish 18 months after they're filed. And so this increases the public knowledge base for inventions that are existing. And the government and society in general sees a benefit from that, from further technological advances. The more knowledge that we have, the more that we can make improvements on what we do, the more that we can improve our lives, both economically and socially. In fact, it's so important to our government system that it's included in the US Constitution. Our founders, centuries ago, realized the importance of patents and included it in the Constitution. Article 1, Section 8, Clause 8, that I have repeated here on this slide, is one of my favorites and probably the favorite of numerous patent attorneys. So, as I said before, I'm going to try to distinguish patents from other forms of IP, which generally these other forms of IP are colloquially known as soft IP in the field. That doesn't mean that they're easy or simple or not interesting. They're in fact the opposite of all those things. I think it just has to do with that patents are generally dealing with hard sciences and inventions, and soft IP is more the creative side of things. So let me try to break down what these are so that you will not get confused between a trademark and a copyright, for instance. So trademarks, again, not dealing with inventions. They are business focused. They are things like words, brand names, symbols, shapes, logos that are used in commerce. And their purposes are to prevent consumer confusion so that a consumer that's going out to buy a pair of Nike shoes is not tricked by some imposter that just formulated a shoe, came out with a shoe and put it on the market that looks just like the Nike shoe that they wanted to get. And then when they get home, they realize, oh, this is not as high a quality as I would expect from Nike. And then they realize it's not from that manufacturer. That is the exact type of consumer confusion that trademarks are trying to protect. Essentially, those are different from patents. In a big distinguishing point is that patents really are out there to protect the patent owner, to give them the right to exclude others from using, whereas trademarks are really out there to protect the consumer. And I have on this slide a couple of pictures that I want to describe. So the one on the left is obviously a bottle of Coca-Cola. And the reason why I'm including that is because there's numerous trademarks just in that one picture. The name Coca-Cola itself is trademarked. The way it's written on that bottle is trademarked. The shape of that bottle is trademarked. So that when you go to a store and you see a bottle of Coca-Cola, you know you're buying a bottle of Coca-Cola and not some knockoff. The other picture I have there is a favorite of mine because it's from one of my favorite movies, Coming to America. If you haven't seen it, I highly recommend that you do so. Part of the movie includes a restaurant that is a clear-cut knockoff of McDonald's. If you just glanced at this slide, you probably thought that was McDonald's and not this knockoff of McDowell's. If this was in the real world, this would almost assuredly be trademark infringement, and they even allude to that in the movie itself. There are no expiration dates for trademarks, unlike patents, if they are used in commerce and fees are paid. Copyrights, are creativity focused, not business focused like trademarks. They are for original works of authorship, such as literature, music, photos, artistic works like sculptures. They need to be in a fixed and tangible form. Um, they are the easiest way, I think, to distinguish trademarks and copyrights, because they can be confusing together, is that copyrights are typically more creatively substantial than trademarks. That's a quick and easy rule of thumb way to know whether you're in the trademark world or the copyright world. Another is the business focus versus creativity focused, and the branding versus creativity. Copyrights are created once you create that work, but registration with the Copyright Office can be beneficial, and the expiration date is quite long. It's life plus 70 years for individuals. Another non-patent form of IP, again, so you can distinguish it from patents, is trade secrets. This is confidential business information that provides a company or enterprise with a competitive edge. This can be an alternative to patents, but like you have a choice, I guess, if you come up with a new invention, especially if it's something that you're doing behind the scenes on the back end of your systems or your business. You could try to keep it secret and maintain that secret sauce that way, or you could try to file for a patent, in which case, again, back to the public disclosure point that I made earlier, you will have to tell the world what you have created. So trade secrets can be beneficial in that you could keep that secret, but one warning I will give is that it's really not recommended when whatever the product is, whatever the service is, can be reverse engineered, especially if it can be reverse engineered relatively easily. And in the arts that I practice in, which are mechanical, electrical, computer, and software, a lot can be reverse engineered. So I hardly recommend trade secrets as an alternative to patents, but for some other technology areas or for some other specific things, it can be useful. I have some examples listed here. I won't read them. And I will note that trademark or trade secrets only protect unauthorized disclosures, meaning that if you let the trade secret slip accidentally, that is, you are out of luck. You have let that trade secret go forever in almost all circumstances. One famous example of a trademark, not to make this a Coca-Cola centric presentation, is the recipe or formula for Coca-Cola. It's rumored to be locked away in some vault in Atlanta, although I've talked to people in the cola industry who say that they definitely know what the recipe for Coca-Cola is in that industry, but it's a good example nonetheless. So turning back to patents, now that you can distinguish other forms of IP from patents, what are the different types of patents? Here are the main different types of patents. You have your utility patents, which I will go into detail on each of these in subsequent slides, but here's a general quick and dirty overview of each of these. You have your utility patents, which are probably what you think of when you think of a patent in general. These are protecting your processes, machines, articles of manufacture, compositions, and things like that. Design patents protect only the ornamental look of an article of manufacture. That is what I refer to as the coolness factor, what it looks like on the shelf, as opposed to how it functions, which would be more in the utility space. And then plant patents, I'm sure you can guess, have to do with plants. They are for new and non-obvious forms of plants that are not naturally occurring. So I'm going to break down or try to break down each of these categories for you. So first you have utility patents, again, the main form of patents. This is language directly from the statute about what utility patents cover. They cover a process, machine, article manufacture, composition of matter, or improvements thereof. Now, I will say that this used to be very easy to figure out what is patent eligible subject matter for a utility patent, and it's become a little bit more muddy in recent years with some, in my opinion, pretty bad Supreme Court precedent in the realms of software and in the realms of diagnostics. But for the purposes of this presentation, just know that if it's not naturally occurring, if it's something that took some innovation on the part of on the part of human beings, it could be fodder for utility patents. It could be the basis for subject matter of utility patents. And hopefully the law will get a little bit more clear in the software space as we move forward. Maybe the legislature will clean that up later. At least I'm hoping that way, and I'm advocating for that. So what are the requirements to get a utility patent? Well, I talked about one earlier about fully disclosing your invention. That's an important one. You do need to describe your invention, again, in a way that enables someone having similar technical skill to be able to make and use your invention. Other requirements that I'm listing here are that it needs to be new, useful, and non-obvious. So let me break each of those down. I'll start with the simplest one, useful. We can pretty much throw that out because almost everything is useful. You can make an argument for almost anything being useful. And so I wouldn't worry about it. I don't know if I've ever even gotten a rejection for something not being useful, and I've filed on some pretty simple stuff in my career. The new and non-obvious is where your invention really will lie about whether it's patentable or not. New is a relatively easier threshold than obvious to overcome. New basically means that if your invention before you filed it didn't exist in almost its exact form in what's called the prior art, that's anything that's older than your filing date for your invention, then you will satisfy the requirement of being new. But if an examiner searches and finds something that's exactly like what your invention is, then you are not eligible for patent protection for that invention. Again, unless it's really close, then new is usually not too much of a problem. Where the challenge usually lies in getting a patent through the patent office is the non-obviousness requirement. So that is a very subjective standard. It's a lot of it rests in what the examiner sees as being obvious. What usually an examiner will do is say that an invention that you've come up with is an obvious combination of things that previously existed. If your widget is simply a combination of existing element A and existing element B, an examiner may say, a patent examiner in the United States Patent and Trademark Office, let's be clear, will probably say, this is an obvious combination of features A and features B. Now, there are ways to overcome that argument. The easiest ways are if feature A or feature B actually didn't exist in the prior art. That's an easy way to overcome the obviousness rejection that you may receive. Another easy way, or not easy way, but another argument that you can make is to say that there was some technological hurdle, something really innovative and creative or problem that you solved by combining these existing elements together, some challenge that you overcame that was existing in the prior art and was the reason why this combination did not exist before. One thing to note about the requirements is that there's no requirement to actually build your invention. Now again, and that's the physical reduction to practice, you do need to reduce it to practice on paper, meaning that you need to, again, as I said before, describe your invention in a way that would enable someone else to be able to make and use that invention. But you don't have to actually build it and send it to the patent office, which is a little bit of a difference from centuries ago when you used to have to build a patent model and send it to the patent office. And if you've ever been to the patent office in Alexandria, I'd encourage you to go to the museum there, which has some old patent models that are really cool to look at. The term for utility patents is 20 years from the earliest effective filing date. This is, I have an about symbol there because it can be a little tricky to figure out because there are maintenance fees that need to be paid after a patent grants, and if you don't, then a patent can expire. Also, there can be delay or added time added to a patent term if there was office delay by the patent office, or time subtracted from a patent term if there was applicant delay. So if it's important to you to know the exact date that a utility patent has or will expire, I would encourage you to contact a patent attorney or patent agent. Design patents. Design patents are some of my favorite types of patents. They, again, protect the ornamental design for an article of manufacture, as I described it before, the coolness factor, what makes it look really good, and not the functional elements of it. The requirements, similar to utility patents, are that it's new and non-obvious. Here, you don't have to be useful because, again, you're just looking at the ornamentality of the article of manufacture, not its function. One warning that I'll give is that some patent attorneys even think if an invention performs a function, then it's not subject matter that could be protected via a design patent. I don't agree with that because if it can look differently and still perform that same or similar function, and you chose it to look differently for a reason because it looked good, then there probably is something that you could protect there via a design patent. But every case is sort of on its own terms. You need to evaluate it. The term of a design patent is much easier to figure out than a utility patent. It's simply 15 years from grant. There are no maintenance fees that you need to pay after. So design patents are actually a little bit cheaper to file for and to get as opposed to utility patents. I have some cool examples, at least I think they're cool, of design patents at the bottom of the screen there. The one on the left is a little Yoda figurine that was put forth by the Lucas company back in the 70s. This was for a toy, I think, that they put out. This is an interesting example because Yoda himself would probably be subject to copyright law, but the little figurine here, you can get additional protection for. That look of that little figurine is what's protected by the design patent. If someone wanted to put out a Yoda that looked different and sell it as a figurine, they may be in the copyright infringement world, but they're not in the design patent infringement world. This design patent would only protect something that looks to an ordinary observer just like that. The middle example I have is one of the older iterations of the iPhone, which is protecting the top look of the screen. It's relatively simplistic. It's just covering the rounded edges where the home button is located and the fact that it's reflective. You'll notice that it has broken lines in this drawing. Broken lines in a design patent indicate unclaimed subject matter, meaning that in order to infringe this patent, that portion that's in broken line can look differently for the product that's allegedly infringing it, but as long as the top portion looks similar, then it can be infringing. And this may seem like a very simple example, but I'm including it because it was one of the patents that was subject to the famous or infamous Apple v. Samsung dispute from a few years ago that resulted in an initial verdict of over $1 billion. So this shows that design patents have value. They really do. They are valuable for a business to have. And like I said before, they can be relatively easy to get in the realm of, especially when compared to utility patents. And then the third drawing that I have here on the right is one of my client's design patents that we got for a water bottle that's also a massage roller. And I think it's a good example of the use of broken lines because we figured that if a competitor was going to go out there and try to steal our design, our look, they'd probably put their own logo on there. So we didn't want to claim the Skills logo, which is the name of the company. And also the top of water bottles can look vastly different, whether they're screw tops or otherwise, or whether they have that hole on them. So we put that in broken lines as well to indicate that it's unclaimed subject matter. All that's really protected here is the look of the massage roller itself and just a very small portion of the top of the bottle. So plant patents. I am not a botanist. I've only filed a few plant patents in my career and only out of client desperation, to be frank with you. So I'm not an expert in this, but they are for new asexually reproduced plants, not from store-bought seeds or otherwise naturally occurring seeds. And the term for them is similar to utility patents. One thing I will note extra about the slide is that I'm including a picture of a cannabis plant here on purpose to let you know that if you are interested in the cannabis space as a business, cannabis related patents are a thing. They are not prohibited. And so that's why I included this. This photo is actually from an issued plant patent on a cannabis strain. So back to utility patents, which are, again, the main form of patents. When you think of patents, you're probably thinking of utility patents. There are numerous different flavors of utility patent applications that you can file or that can go into a filing strategy for a company. And again, I'll talk about these in detail in subsequent slides, but let me give a quick intro to what each of them are in a nutshell. So provisional patent applications, those are basically placeholders used to secure yourself a filing date with the patent office. They themselves never issue into a patent. They are there just to be used to claim priority to by a subsequently filed non-provisional patent application, which is number 2 there. These are what I refer to as real deal patent applications that have strict formal requirements, are actually examined by an examiner in the Patent and Trademark Office, and would hopefully actually issue into a granted US patent. The third is international applications. Sometimes these are referred to as PCT applications if they are filed under a treaty known as the PCT. I will explain that further, but one thing to know is that patents are territorial. So if you have a US patent and only a US patent, and there's someone infringing your patent in Germany and only Germany, or China and only China, and not importing it into the US or otherwise not having US customers buy them, there's not much you can do. So there are global tools that you can use to sort of act as a placeholder for filing protection for your invention in different countries, and the PCT is one of these tools. You could also just individually file a patent application simultaneously in the United States, in whatever countries you want, in China or Australia or wherever. There's really an abundant amount of filing strategies that you could use internationally. But I think the most important one for this context is PCT applications. So I'll explain that a little bit further. And then continuing applications, which are simply applications that claim priority to non-provisional patent applications. Patent applications that are filed after a non-provisional patent application, but refer back to them. So provisional patent applications, as I said before, they don't actually issue into a patent, and so there's less formalistic requirements, actually no formalistic requirements. They can then be a quick and inexpensive way for inventors to establish a filing date for their invention. So why is it important to establish a filing date for your invention? Well, in the US, we are what's known to be a first to file country, meaning that if I invent something and independently from me, someone else invents it in California or somewhere else in the world without stealing the idea from me, they just came up with it on their own independently after I did, but they filed for a patent first, technically they have the right to that patent protection, not me. So it's a first to file country. In a way, you can think of it almost as a race to get a filing date. Another reason why it's important to get a filing date is because the filing date, if it's a dually occurring filing date, meaning you fully disclose your invention on that date, that is the date in which subsequent non-provisional applications that may claim priority to your provisional will be judged for novelty and non-obvious. An examiner will only look at prior art that exists before your filing date. So it's important to get that filing date as soon as possible. A provisional application, again, I equate it to be a placeholder application for filing a non-provisional. You are only able to claim priority to it a year after its filing, or within a year from its filing, said better. So it expires after 1 year. If you wait a year and a day, you cannot claim priority to your previously filed provisional application. So once you file a provisional application, a little clock in your head should start about when you need to follow up on it, and that is a 1-year clock. There is no such thing as a provisional patent. It's only an application. Again, it does not issue itself as a patent. You're only using it to hold your place in the line, establish a filing date for a subsequently filed non-provisional application. It is relatively low cost, as I said before, $140 for a small entity, which is defined primarily as a company with 500 or less employees. If you compare that to the non-provisional filing fees for a small entity, that's about $800, so it's a lot cheaper, and you can double those numbers if you're a large entity, meaning more than 500 employees. As I said before, there's limited formal requirements because it's not actually examined, so you don't need a claim, an oath or declaration. What you do need is a specification, which can take many different forms, and drawings, the statute says, where necessary. I will add that in my view, drawings are almost always necessary to understand what an invention is, to satisfy that duty of enabling someone else to be able to make and use your invention. I have a picture of a cocktail napkin there because the colloquial example that we give in patent law is that there's such little formalistic requirements for a provisional application. It can be as simple as a sketch on a cocktail napkin. While technically that may be true, I don't know whether that would really satisfy the disclosure requirements to make it be worthwhile. So I wouldn't recommend it, but it does stress the fact that there are limited to no formal requirements for a provisional patent application. And so I think it's useful to talk about. It does provide that 1 year that you can use to claim priority can be a buffer before your non-provisional to do all kinds of interesting things, which I'll touch upon in the next slide. So it can be beneficial from that standpoint. And again, a priority date would be given to a duly filed subsequent child application, that non-provisional application, if your claim is fully supported. If the claim in a non-provisional patent application is fully supported by the material that you filed in a provisional application and you claim priority to it, you will be given that benefit of the priority date, which again can be important for all different reasons. And if you choose not to act on your provisional patent application, and if you kept it secret for that year, provisional patent applications will then never actually publish. They only publish in a later, if a non-provisional application then publishes and claims priority to it. So if you just give up on it, no harm, no foul, it will stay secret in the patent office database. database. So why would you file a provisional application? Well, like I said before, it gets you a filing date as soon as possible. And if the invention is properly disclosed, again, you want to treat this almost as a data dump, giving the patent office all the details about your invention as they exist on that date. That is the date in which your subsequently filed non-provisional application will be tested for novelty and non-obviousness. And also you can use, because it's a relatively cheap and inexpensive filing, you can use the 1-year pendency period of a provisional application to do all types of interesting things, such as raise money for your company in general, or for the filing of that subsequent non-provisional application. You can determine sales potential for the invention to figure out whether you want to follow up on it or not. You can use that time period to experiment or perfect the invention or design, which I will give one warning there. If you come up with improvements or changes along the way after you've already filed a provisional application, I would almost always recommend filing what I call a follow-on provisional application, which is just another provisional application that adds in those extra details that you've come up with through experimenting or perfecting the invention. Because again, you only get the filing date for whatever material you disclose. So if in a later non-provisional application, you want to claim one of those improvements, technically those improvements will only have a filing date for when those improvements were included in a filing. And so if they were never, then they only have the filing date of a non-provisional. If they were filed in a follow-on provisional shortly after their creation, you've created a roadblock for where novelty and non-obviousness will be judged. And as well, you got a filing date so that if someone independently came up with it but hasn't filed before you, you have the right to protect it, not them. Provisional applications can be very useful for eminent public disclosures, such as a presentation or a lecture, or publishing it in a paper, or offering it for sale, which counts as a public disclosure. This is probably, so if you tune me out a little bit, maybe pay back attention here, because this is maybe the most important point in this entire presentation, is that public disclosures before you have a filing date are not your friend in the patent world. They are very dangerous, and I can explain why. So the United States is a little bit of an anomaly and very friendly in this sense in the patent world. The United States gives you, an inventor or someone that has the rights to an invention, 1 year from a public disclosure, which again, offer for sale or an actual sale counts as a public disclosure. The United States gives a 1-year grace period before you're required to file a patent application for that invention, or you forever forgo patent protection for that invention. So if you make a public disclosure today, which is, it's November 13th, 2019, and you don't file something on that invention before November 13th, 2020, you have forever forgone patent protection in the United States for that invention. And I said before, we're a little bit of an anomaly in this space, the United States in general, because there's a lot of jurisdictions worldwide that aren't as friendly, do not give any grace periods whatsoever. They're known as absolute novelty jurisdictions. For instance, Europe is pretty much an absolute novelty jurisdiction. If you disclose your invention, and before you have a filing date, before you filed for a patent application, you may have forever forgone patent protection in all of Europe. Again, I am a US patent attorney only, so this is something that you'd want to check with your patent attorney, who would, of course, check with European counsel. But from my experience, just know every patent attorney worldwide would pretty much agree that public disclosures are not your friend before you have a filing date. So get that filing date as soon as possible before making any public disclosures. That's my best advice. Also, provisional applications enable you to mark your materials or products as patent pending, which can be very useful for marketing. You hear it on TV all the time. So non-provisional patent applications, these again are what I refer to as real deal, really technical term there, my real deal patent applications, because they are a very formal legal document. This is self-serving, but they're best prepared by professionals such as patent attorneys or patent agents. I would never recommend doing this on your own if you're not a patent attorney or patent agent. They will be examined and they would hopefully issue as a patent. The contents are pretty, again, there's formalistic requirements here. You need to have a specification, which would include a detailed description of the invention. You'd need to have drawings when necessary, is what the statute says, but I would say almost always. And then claims. Claims are, if you've ever looked at an issued and granted US patent, at the end of the patent document, you'll see one or more numbered items. Those are the claims. A judge in the Federal Circuit has once said, the name of the game is the claim. So the claim is what defines the scope of protection for your invention. In order for you to prevent others from making, using, and selling your patented invention, you're really protecting what is patented in the claims, not in the specification or the drawings, which can be the same materials as what you're claiming, but the claim is what will be analyzed in court to see whether someone is infringing your product. And it's an art drafting these claims, which is why I would never recommend you drafting one of these by yourself if you aren't a patent attorney or a patent agent. The key with claims is that you need to satisfy the requirements for patentability that I mentioned before, which again are that it's new and non-obvious. So you need to include enough features so that you're different from what existed before. But you don't want to include so many features that it would be easy for someone, a competitor, to design around your claims. And so it's really a fine line that patent attorneys and patent agents try to walk when drafting claims. Another requirement for a non-provisional patent application is the oath or declaration, which is basically an inventor saying, yes, I invented this and I reviewed this patent application. And fees, of course. The United States Patent and Trademark Office, USPTO, will not do anything unless they received their fees, which again are somewhat substantial for a small entity, company less than 500 employees, double that for a company more. And again, this covers the examination procedure through the patent office, which if you hear the word, the term patent prosecution, that's just a fancy way of saying the examination procedure and what you do in response to that examination procedure while your patent application is pending. Typically, it's quite expensive to prepare, prosecute, and enforce patents, which is why I had said I had a self-serving bullet point earlier in the slide with that they're best prepared by professionals. Here's my non-self-serving bullet point, is that they can be very expensive. And so it's not something that you want to go into if you're not serious about protecting your invention. So PCT applications, again, this is an international filing that acts as a placeholder for later filing a patent application in one of the participating members of the Patent Cooperation Treaty, which is what PCT stands for. There are over 150 plus countries and territories that participate in the PCT. It's basically any industrialized nation that you'd ever want to protect something in. There's a few notable exceptions. I think the most notable exception is Taiwan. They're not a PCT member, but otherwise, pretty much any industrialized nation in which you'd want to seek patent protection is a participant in the PCT. They are the countries highlighted in blue on that picture on this slide. So the way a PCT works is it's a similar document to a non-provisional application. In fact, mine almost always look exactly the same as my non-provisional applications. And instead of filing it with the USPTO, which you can file it with the USPTO, but you file it with a different cover sheet in a receiving office, what's called an international receiving office within the PTO or within another foreign patent office. And basically that PCT application, again, it's a placeholder, will sit there until a deadline for filing in one of the participating countries comes up. Now, a PCT application, unlike a provisional application, which again is also like a placeholder, a PCT application differs because, again, those formalistic requirements, but also because your PCT application will be searched and it will have a written opinion issued on how an examiner has viewed these claims. You have no duty to respond to that, and you may not want to respond to it, but it can give you a good gauge about the prospects for patentability of your invention. So a PCT can be very useful from that standpoint. It can also buy you a lot of time. The deadline for most countries that participate in the PCT to further act on it, to file a real patent application, to convert that PCT, which is called entering the national stage in whatever country you choose to file, is typically about 30 months from the earliest priority date. So if you want to kind of buy yourself some time to figure out where you want to file a patent application, a PCT application is a good way to do it. And it also is a valuable piece of intellectual property in that investors and people that have somewhat sophistication in the patent world recognize that we're in a global society, and the ability to file in a number of countries is more valuable than the ability to file in just one country. One thing I'll also note here is that although there's numerous countries that participate in the PCT, no company out there is filing a patent in all of these countries. Even the biggest companies in the world only choose a handful of these jurisdictions to file in, typically where they see their client base, or they have potential for a client base, or where they're manufacturing or doing something like that. They will typically only a handful of countries, because it can get quite expensive quite quickly, and also you're not going to enforce your patent in all of these jurisdictions. You're really just not. Continuing applications. So again, these are sort of follow-on applications to a non-provisional, and they come in a few different flavors. I'll try to quickly go over them, but I don't think it's super important for this presentation. One is a continuation, which is basically the same exact spec and drawings that you filed in your non-provisional. You refile it while your non-provisional application is pending, with different claims. And you could do this for a number of different reasons. Maybe you want to broaden the scope of the claims. You thought you went in a little bit too narrowly on the first pass, and you think you can get something broader. That may be your reason. Maybe vice versa. Maybe you want to claim it more narrowly for whatever reason. Maybe you see an infringer out there doing something that you think you can claim in your patent application because you have support for it in your specification and drawings, which again, in a continuation, you can't change, only the claims, and the claims need to be fully supported by the specification and drawings. So you file a continuation application and go after that potential infringer that way. Or your specification and drawings had numerous inventions included within it, and maybe you want to now try to claim a different invention. So it can be very flexible and very valuable for a company. A divisional is essentially the same thing as a continuation, but it's when an examiner has already told you that your claims cover more than one invention and you have to pick one. And so you pick one, and then almost reflexively you file what's known as a divisional application, which is just the same application but going after those different claims that you didn't select in the first pass. A continuation in part, otherwise known as a CIP, is similar, but it contains new matter. So something in that spec and drawings is different from your original filing. It can be a polarizing topic amongst patent practitioners, as I say here. So if you are working with a patent attorney that mentions the filing of a CIP, I would actually advocate for you to push back a little bit and ask why, because I think there's a place for them, but there could be limited circumstances, because it can affect the term of a patent without getting the benefit of the priority date, because any new matter that's claimed will only get the filing date of the CIP, not the earlier filed non-provisional. But again, this is a little in the weeds stuff. Just know that they exist, I think, for the context of this application. So why would you file these continuing applications? Well, it keeps the patent family alive, and that is insanely valuable because it provides flexibility. You can then, as I said before, see what potential infringers are doing and adjust your claims accordingly, as long as you have something pending and alive. And so continuations can serve that point. It can add value to your portfolio because investors and otherwise realize that if you have something pending and you have that flexibility, it adds substantial value to your patent portfolio. I really hate to see when a startup has a really great invention and they file a patent application and they get a patent and then they stop. I would almost always advocate for filing a continuation in almost any circumstance, as long as the budget allowed for it. I have clients personally that have applications pending, or families that have been pending since 2009, and some even before. I think it's a little crazy. It can get a little out of control with keeping something pending, but it's always beneficial to have it than to not have it. And it can be used as a backstop for mistakes or unforeseen events. If you think that your claims may be subject to attack for one reason or another in a previously filed application, you can clean it up a little bit in a continuation. So here's an example timeline of a filing strategy for patent applications. I will say there are numerous strategies. So this is just one, and this is just one example, I should say. It's not even really a strategy, although it could be. So let me walk through these circles, which represent moments in time. So at the first circle, you have your invention. And then, as we said before, you want to get that filing date as soon as possible. So at the 0-month timeline, you file your provisional application. So as I said before, provisional applications are pending for 12 months of when you can file or claim priority to them. So let's pretend in this example timeline, timeline, at the 12-month mark, you file a PCT application, which again, the United States is one of these participating countries. So instead of filing a US application, you can file a PCT and then later file a national stage entry off of that PCT into the US. So let's pretend at the 12-month mark, you file a PCT, and then at the 30-month mark, which is the 30 months from the 0 months, 18 months after that 12-month filing, because it's 30-month pendency from your earliest filing date, you file a US application. And then if we really pretend that the patent office has their stuff together, they're supposed to examine stuff 14 months after filing. I will warn you that that hardly ever happens, but if they're doing so here, let's pretend they're super efficient. At 14 months, they pick up and start substantively examining your application. And then super quickly, 6 months later, you have a granted patent, and previous to that, you file a continuation. So as you can see, this can be a very long process, and this is somewhat accelerated from that 30-month period on. But it can drag out quite long. So be comfortable with your patent attorney, because it may be a 5+ year relationship for just one filing. It can go that long. So here is a very important slide, I think, in this presentation. It's, you have a great idea, so what do you do now? Very self-serving bullet point, but one I truly believe in is that you should contact a patent attorney or patent agent, someone in this area that knows what they're doing, because as I've said before, you can make some really detrimental mistakes that can adversely affect your patent protection moving forward, such as making a public disclosure, even when you don't know that you're doing so. So my second bullet point here is to keep it secret and/or file a patent application as soon as possible. Again, public disclosures are not your friends before you have a filing date, and even the safe bet is to keep it secret until you have an issued patent. That is somewhat unrealistic for a lot of inventions, but it is the super safe, super conservative way to move forward, is to just keep it a secret as long as possible. I know that that's not really a possibility in an entrepreneur or startup world where what you're seeking to patent may be the thing that you need to go out there to sell to make money. So in that instance, I would just say, let's get a filing date, a quality filing date, as soon as possible. And as I said before, provisional patent applications can be a quick and relatively easier way for startups and entrepreneurs or people with limited budgets to get that filing date. Again, I would push for the more disclosure, the better, so that you have support for a duly filed non-provisional that wants to claim priority, so you actually get the benefit of that filing date. And one thing I haven't mentioned yet is that patentability searches, that's a search that's done to look at prior art to see what kind of challenge you'll see in the patent office when you're trying to get a patent through. Are really valuable. They really are, because they can give you that insight about whether it's worth it to file a patent application. But one warning I'll give is that I would always recommend that a professional search agency conduct patentability searches. I farm all mine out to a friend of mine that has a patent search organization, because he's a lot cheaper and a lot better, frankly, than at me. And I recommend this for a couple of reasons. The first is, as I said before, they are good at what they do. There's search companies that all they do is search. So they know how to put together very useful search strings. They know what databases to look in to try to find things, and they'll look in the same places that a patent examiner will look into. Another reason is that anyone involved in the preparation or prosecution of a patent application has a duty to the patent office to disclose any material prior art. And it's better safe than sorry here. So if you did your own searching and you come across a piece of close prior art, but you didn't keep good records about it and you didn't submit that to the patent office, your entire patent can be invalidated for that reason. So if you have a third-party searcher perform the search, they will give you a report, it will have results in it, and you can almost reflexively just take those results, copy and paste them, and submit them to the patent office as potentially material prior art. It's just the safest way to proceed forward. If you do your own searching, I would recommend keeping relatively meticulous records on it. I know I've covered a ton of material so far, but this was probably one of the more important slides that I have. So the next ones I'll just try to get through quickly, so maybe we can end early or take some questions. So the value of patents to a business. As I said before, it can create a finite monopoly for your company, or essentially create one, which can be extremely valuable if you can prevent your competitors from doing what you want to do. That can be really just a make or break for your company. It's a key factor usually for investors. They will look at the scope and the quality and the quantity of, frankly, of your patent portfolio. Sometimes it's a numbers game. Sometimes just generating more patented material is just more lucrative to investors for one reason or another. And again, as I said before, having pending patent applications can have a ton of value. I see it as if you have a portfolio that has an issued US patent and a pending US application, that is much more valuable than a patent portfolio that only has issued patents. Again, you can do all these things that I list in these bullet points. You have the flexibility to capture unrealized value, capture some clever infringers and design arounds as long as you have support, and you can, change the scope of protection as you see fit, as long as you have support. You can enforce your patent, and again, it's a pretty fungible piece of property that you can sell or license as you see fit. So, patent enforcement, I will just say that it's very expensive. It really is. I'm not a litigator. I have done litigations in my past. I don't like them, which is why I don't do them. They are a very expensive process. If you find yourself in a litigation, it's almost always painful, but it can be quite lucrative. Some of the monetary damages that are issued are quite substantial, and sometimes even just the remedy of injunctive relief, preventing your competitor from being able to make or use a patented invention when a judge says that they can't, is quite valuable. I will say that usually these start with just a simple cease and desist letter, which can be effective. It sort of depends. And then usually these end without a final disposition in a court. Usually they're negotiated or settled before that final decision, before a trial, a jury verdict, or whatever. I think the statistic is over 95% of patent cases are settled beforehand. Usually people play relatively nice in the patent space. So I think that covers everything that I wanted to. So I don't know if there are any questions or not. One thing I will try to just promote myself here is that that is my business account for Twitter, which I think is fun. I include some little patent tidbits here or there, and some nerdy tweets related to patents. So I'd encourage you to give it a follow if you'd like. But otherwise, you can feel free to contact me. Ellie, I don't know if we have any questions or if we should wrap up or how that went.
Yeah, thank you so much, Tom. That was such an interesting presentation. I really appreciated it. We will take a couple questions. We still have a couple minutes left. Just a reminder for those that are tuned in, you can type your questions into the question box at the GoToWebinar control panel. Tom, the first question we have for you, it's actually personal. It's about you. Some of the audience was curious, what sparked your interest in patents and the patent law world?
That is an interesting question, and it's a very University of Maryland specific answer. I was in one of the upper level undergrad classes for engineering, and it was one of these creativity focused classes of where our assignment, I guess, was to research and write a paper on an interesting non-traditional engineering career. And I was in this class. Dr. George Dieter was the professor, and he had seen through my previous work that I was a good writer, which sometimes is rare in the engineering world. And so he encouraged me to research the career of being a patent attorney, and I found it very interesting. And so I kind of put it in the back of my mind that, okay, well, if I want to go to further school and I want to do something else other than engineering, then patent law is one of my options. And when I got into engineering, what I was doing in New York City got a little redundant. It was in building construction. And so that sparked the idea to try to go to law school at night and see what happens. And I did. And I don't regret it one second. I really love what I do. I'm one of those few people that love what they do. It's always different. It always has to be, right? New and non-obvious. So I really do enjoy it.
Great, thank you for sharing that perspective. The second question we got was around your slides. I think a lot of people found your presentation very helpful, and we're wondering if you would be willing to either share your slides or would be open to providing similar materials as they go through their entrepreneurial journey.
Of course, absolutely. This is contrarian to the patent attorney world of where we want to keep things secret and tight to the vest. But no, absolutely, I will absolutely share these slides. I can PDF them and provide them to Ellie, who then can circulate them to any of the participants.
Great, thank you. It looks like we've covered all of the questions. Is there anything, Tom, that you wanted to cover before we wrap up?
Just the bigger takeaways. Again, I think if you're going to remember anything out of this presentation, I think the keys are be wary of making public disclosures about what you think could potentially be an interesting invention before you have a filing date. And then just, it's really that it's a conundrum that a lot of startups find themselves in. I know because I deal with it all the time about, well, how do I get the money to file a patent application when I can't sell my product without giving a public disclosure? It's sometimes a balance that you have to strike when you have a new company or a new idea. So I have sympathy towards that, but it is an important point and it can be very detrimental. So I would say one big takeaway, if you're going to remember one thing about this presentation, it's be wary of public disclosures.
Awesome. And it looks like I spoke too soon. We had a couple questions come in last minute if you're still willing to answer. Great. So one of them is coming from Troy, and he's asking, are entities like LLCs able to apply for patents, or do individuals' names always appear on the grant?
So those are kind of two separate questions in one, but I'll tackle each. So an entity cannot in the United States invent something itself. It needs to be a human being, one or more human beings that invent it. And until that invention is assigned to a company, it is owned by the inventors. So you'll always see in a US patent the names of the inventors listed on there, but that doesn't mean that they're the owners. And I would say in most cases, they're probably not the owners. An entity that employed them or that they started themselves is the owner. So an entity itself can't patent something as far as being an inventor, but an entity surely can and does become the applicant for a patent, if that makes sense.
Got it, thank you. And the last question we have from Christopher is, what was one of your most fun cases that you can discuss with us?
Ooh, a lot of them. I mean, most of mine, I think all of mine settled, but we scared away. There's this term in patent law known as patent trolls. These entities that are non-practicing entities is what they're called, NPEs, which are companies that just try to secure a bunch of patents and then sue other companies that are actually making things. And it's a very polarizing topic. I actually have mixed feelings on it. But in this one instance, it was a pretty egregious lawsuit based on our client was a perfume manufacturer, and they had some display cases that were in like drugstores and retail places like that. And this one company, non-practicing entity, had bought all of these like cardboard related patents, and they sued us for infringing that, my client for that. And it was just totally off base. Like nothing was even close to it. They were just fishing for us to settle, our client to settle. And we actually, as lawyers, I think we advocated for them to settle because it would just be the easiest way to do it. But the client was like really adamant about us fighting it. And so we found that this was so egregious that we told the judge that we think that this is possibly in the realm of for sanctions against the attorneys that brought it for bringing such like a BS lawsuit against our client. And the judge issued an opinion that was very harsh towards our adversary that made our client extremely happy. And although I think they probably spent more money on the case than they would have if they just settled, they walked away very satisfied. So that was a cool one, just because it got a good result for the client and kind of shot down some egregious behavior.
Yes, awesome. Thanks for sharing. You called them trolls?
Patent trolls is what non-practicing entities are sometimes referred to. That is a very polarizing topic. Even any non-practicing entity, if they were listening, they would probably be very offended by that. But everyone in the patent world knows what a patent troll is.
Yeah. Well, thank you again, Tom, for taking time out of your day to chat with us. And thank you, everyone, for joining us. If you have any remaining questions, please feel free to reach out to Tom. His contact info is on that last slide there. And hope everyone has a wonderful day, and go Terps.
Yep. Thank you, everyone. Go Terps.